Good morning. Started one of the first things I said during jury selection was I told you a story about Bill Harrell and Jimmy Eastep and the objections and being concerned about doing something that you may hold against my client. And I want to start back there again about where this judge was sort of getting on to a lawyer and said, if you do that one more time, I'm going to hold you in contempt. And the guy walks out of the courtroom and asked my dad to come ask the lawyer up there. Said, what are you doing? The judge about to put you in jail. He said, hold this knife here. I'm going to go back in there and ask that same question. He did go back in there. He did ask the same question in front of the jury. The judge put his head in his hands, shook, got him to go to jail. But I'm reminded of some of the things I've done in this trial that I'm worried about that maybe I have done something wrong. For example, the issue with Karen Warren. You may recall Karen Warren testified and I was trying to show a video and I got her confused with somebody else. And I don't ever want to think that somehow that I've done something that would make you not believe what I'm telling you. So it's very important that I don't do things like that, and I apologize. I think I apologize to Ms. Warren. Second, out of 86 jury questionnaires, not one juror knew me or Mr. Allen. And I say by after this trial, you wish you'd never met us. But nonetheless, I do want to thank you all from the start of your jury questionnaires, filling those things out accurately, completely, gave us a lot of information. I know y'all worked hard, and I want to thank you for the work that you put in through this trial. I know y'all this may be your third week by now, maybe even the fourth, I'm not sure, through this jury. So I do thank you for the time and attention that you've applied in this trial. I know it's been a difficult case. I do want to start with something that Mr. Allen and I talked about in opening statements. No person in this courtroom can hear these facts and not have sympathy. I submit to you that it is without fail that you would have sympathy. And it was interesting how Mr. Allen in his closing arguments talked about not having sympathy. And I know what he's saying. He's saying, and it's true, you cannot use your sympathy to factor into your decision. That's what he's saying. But he says, you can't have sympathy. And his argument was, have sympathy for the Emma Walker family, but not for Riley Gaul. And I know it's a cliche. And I anticipated that as much in this case, and got to thinking about justice, just justice in and of itself. And our lady justice in our system is blind. She's blindfolded. And that means that you can't have sympathy for one side or the other. I submit to you, Mr. Jerry, it is perfectly natural and normal for you to have sympathy. I also submit that you cannot use that sympathy for one side or the other, because justice is blind and you all are the side in this case of justice. So I'll tell you that I have prepared these remarks. I've tried to structure them in a way not to confuse you, but to help you in your decisions in this case. If they confuse you, I'm sorry. It was not my intent to do that. And I will submit that I have also structured these in a way that's a little different than the way they're ordered. You know, count 1 is premeditated murder, count 2 is especially anybody stalking, count 3 is theft, count 4 is tampering with evidence, count 5 is reckless endangerment, count 6 is employing a firearm during the commission of speculative stalking, and count 7 is the felony murder. But I had to structure these in a way that I felt would make more sense, would be more coherent. And so as I go through this, we'll go ahead and get started. So in preparing for these closing remarks, I go back to the verdict that you all have to decide. And the verdict is this kind of comes from the word verdictum and means truth. So you all will decide the truth. That's what, by your verdict, you all will decide. I want to talk about the cell phone tower map for a minute, and it was Exhibit 348, and I'll go ahead and give it back to you, Chris. But the one that Mr. Allen used in his closing just a moment ago is this big blown up picture. And if you recall in the opening statements, Mr. Allen, when he talked about this, after Mr. Gaul had entered a plea of guilty to reckless endangerment, we'll talk about that in a second, he basically said that this map didn't have a lot of relevance. And this is a cell phone tower map. This is where they were going to show Mr. Gaul was here, he was there, he was there. Because the state thought he was going to come in here and say it was not him who fired the shot that resulted in his death. That's why they said that. And I submit to you that based on his lies to his grandfather, to law enforcement, and other people, that they had every reason to believe that. My 18-year-old client, every reason to believe that. Every reason that he would continue his irresponsible conduct. And so as I told you in our opening statements, we pled guilty to reckless endangerment. We'll get to that in just a second. But reckless and responsible are enemies. Responsible, the truth, doing the right thing, all of those are inconsistent with my teenage client's conduct. In count 5, the state of Tennessee, through the grand jury, by probable cause, obtained count 5, and it says, unlawfully and recklessly engaging conduct that placed another person in imminent danger of serious bodily injury. And my client has accepted responsibility for that count. He has pled guilty to reckless conduct. I didn't put the word reckless in the indictment. The state put it in the indictment. And you'll see in a minute that's not the only place that they put that language. As I told you in the beginning of this trial, the state must prove beyond a reasonable doubt the culpable mental state of the accused at the time of the offense, and you must consider all of the evidence. And I want to talk about all the evidence just a second. Sometimes we as defense lawyers get criticized for not offering a case in chief. But as you all do when we start a jury selection, it's the state's burden to prove beyond a reasonable doubt each and every element of the offense charged. We introduced evidence, we introduced exhibits to the state's witnesses. And by that evidence, you are permitted to weigh that along with the state's evidence as though we had recalled those witnesses, put them back on the witness stand, and went through all that again. And it just makes inefficient sense to try to do something like that. So, submit to you that after you've heard all the evidence, and as I told you in the very beginning of this trial, you will hear some bizarre, reckless conduct regarding my teenage client. On direct examination, Jim Walker, my client's grandfather, who was with my client when he was born, said Riley was having a tremendous emotional crisis. Known Riley since birth, knew there were difficulties with him and Emma. When the gun went missing, he was concerned that his grandson would do something with that firearm to hurt himself. And not only did Jim Walker give us some information about a tremendous emotional crisis, you also heard from Max Siegel, another witness called by the state that we asked, and he said that Riley had lost 20 to 30 pounds, that Riley was in a dark place, that he was somewhat of his mentor or brother because of the difficulties in transitioning from high school to college. He also said that Riley would call Emma crying and weeping. Regarding Alex, Isaac, Noah, and Seth, all of these people talked about Riley having emotional issues going on. Even Isaac said it. Talked about suicide. And I think you saw records that were seized from, or photographs that were taken at Riley's car at Maryville College of some of those records, and the photographs are in the exhibits for your review if you would review them. But as I told you at the beginning of this trial, this case is about state of mind, and this is where it gets a little, so what I'm going to do, the argument that I'm making, is going to be as it relates to first-degree premeditated murder, second-degree murder, and voluntary manslaughter, because the definitions of intentionally and knowingly for those three charges, for those three offenses, homicides, are different than your other definitions for intentionally and knowingly. So regarding first-degree premeditated murder, the definition of intentionally means that the person had the conscious objective or desire to cause the death of the alleged victim. Regarding voluntary manslaughter, intentionally means the same thing. The person acts intentionally with the person's conscious objective or desire to cause the death of the alleged victim. And this will be in your jury instructions. This will be, you will have this, but I'm trying to make this argument more coherent. Regarding second-degree murder, the definition of knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. So if we go back, conscious objective or desire to cause the death, reasonably certain to cause the death. All three of those definitions in our homicide counts as lessers, and we'll get to that in a second, are include resulting in death, causing the death. And so what is reckless homicide? And here's the definition. Recklessly, you'll get this, there's another section in the instructions that you have, and it has a bunch of general definitions, and the definition of recklessly is defined in that portion. And so here's the definition of recklessly. It means that a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Here's the definition for criminal negligence or criminal negligent homicide, where a person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. These definitions will be provided to you in your jury instructions, but it's to help facilitate. So, first-degree murder requires intent to kill as opposed to just acting intentionally. Second-degree murder requires awareness that the person's conduct is reasonably certain to cause the death of the alleged victim, and intentionally involuntary manslaughter requires that the person have the conscious objective or desire to cause the death of the alleged victim. Now, Mr. Allen referred to counts 1 and count 7 as the bookend cases. So I've tried to structure this argument in a way where I talk about both the ones that I've been talking about, first-degree premeditated murder and the lesser included offenses, we'll talk about that in a second, and the felony murder in one context. You consider them separate, but it's for purposes of this argument. So here's order of consideration. So this is I'll give you an illustration. So order of consideration, the judge is going to give you this instruction. And the way you consider charges in the presentment is, so you consider the charges contained in the presentment. If you unanimously find my client guilty of that charge beyond a reasonable doubt, your verdict will be guilty of that offense and you move to the next count in the presentment. If, however, you unanimously find my client not guilty of that offense or have a reasonable doubt of his guilt for that offense, then you must find him not guilty and go on to consider the next lesser included offense in order from greatest to least. So, for example, count 1 charges my client with first-degree premeditated murder. If you unanimously find beyond a reasonable doubt that he's guilty of that offense, you would return your verdict of guilty for that count and then proceed to count 2. However, if you unanimously find him not guilty beyond a reasonable doubt or have a reasonable doubt as to his guilt for premeditated first-degree murder, you will then proceed to consider the next lesser included offense of second-degree murder, and so on. So what are the lesser included offenses of first-degree premeditated murder in count 1 and felony murder in count 7? Second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide. And those will be available to you as you review counts 1 and count 7. So regarding first-degree premeditated murder, what are the elements? The elements are that the defendant unlawfully killed the alleged victim and that the defendant acted intentionally. A person acts intentionally, and you've heard this a couple of times now, when it's their conscious objective or desire to cause the death of the alleged victim. And number 3, that the killing was premeditated. The definition of premeditated is quite long. I didn't include it in this, but I will ask that you look inside there. There has to be a desire to kill, and we certainly say Mr. Gaul did not have a desire to kill. So, but I won't be talking about premeditation so much as it relates to the element. And so, these are the 3 elements that the state would have to prove Mr. Gaul guilty beyond a reasonable doubt for purposes of first-degree murder charged in count 1. So here's where things get a little interesting, and it's a little confusing. And so, regarding count 7, Mr. Gaul is charged with felony murder in the attempt to perpetrate aggravated child abuse. The attempt to commit aggravated child abuse means that you have to have the intent to commit an injury. And you'll see that because child abuse is defined as other than accidental means causing injury. There's a couple more elements. And so you have to have the actual intent to commit, to cause the injury. And so that's where it gets a little confusing with this. The defendant unlawfully killed the alleged victim and that the killing was committed in the attempt to perpetrate the alleged aggravated child abuse. That is, that the killing was closely connected to the alleged aggravated child abuse and was not a separate, distinct, independent event. And that the defendant intended to commit the alleged attempt to commit aggravated child abuse. Any form of child abuse requiring an injury has to be by other than accidental means. We're going to talk about accidental means here in a minute when we talk about Bobby Jones, the accident reconstructionist that came in here, which I think is kind of coincidental that the state is using an accident reconstructionist to try to prove intent, but nonetheless they have offered Bobby Jones an accident reconstructionist to prove intent. So here are all the reasons, and the heading is intentionally knowing the attempt to commit aggravated child abuse. So all of these are talking about, when I put this up there, I'm talking about first-degree premeditated murder, I'm talking about second-degree murder, I'm talking about voluntary manslaughter, and I'm talking about felony murder. And here are some reasons we submit to you that there are reasonable doubts as to why my client did not have the intent to kill or otherwise cause Emma Walker's death. So here is a text message that we have, a screenshot that we have from Alex McCarty, 36, and this is at 11:51 a.m. on November 21st, 2016. And what he says to Riley is, "Bro, are you doing okay?" Now this is after Ashley Donlan has notified Riley that something's wrong with Emma. This is after Riley has told Andrew Stanley that they found Emma hurt. This is after David Wise has been to Riley Gaul's home. And this is Alex McCarty saying, "Bro, are you doing okay?" "I'm not, but thank you." on down, and I didn't put all the screenshots up there. They're in the exhibits. You have every right to them. What Alex says here at the bottom, dude, just tell me what's going on. Did she get shot? At this point, Riley, and the reality of his reckless conduct, his bizarre behavior has sunk in. And this is what he says. Alex, I really can't talk about any of it without breaking down. Just promise me you won't talk to them again. And we'll talk a little bit about all the stuff with the tampering with evidence a little bit later. But the purpose of this is to show, we believe, that Riley did not mean to hurt her and cause her death. Now, so, obviously, if you can see the person you're shooting, that will give you some intent. That will give you some knowingly, as it relates to the homicide counts. That will give you the intent to cause death. Bobby Jones, motor vehicle accident reconstruction and 3D forensic animation, Exhibit 327. Sun shining, windows up, blinds are up, and that exhibit was introduced in this trial, part of one of his presentations. What we know, however, because Bobby Jones did not go to the scene, what we know, however, is that Nikki Buells went into the house. You remember her testimony. She's the one that took some photographs inside the home along with Stansbury. I think Nathan Stansbury went in there as well. But Nikki Buells testified as to how they went about taking photographs. You remember, she says we go in a clockwise rotation, go from left to right, and as we went through those photographs inside the bedroom, she went from left to right, went outside, she took her photographs, started on the back deck and took pictures around this way. So her practice is to go in a clockwise rotation, same as she did with the placards. We'll talk about the placards here in a minute, 1, 2, 3, and 4. But what we know is, when we look here, the window, you can't see that the window's closed, but we see the blinds closed, and we see the mirror pushed up against the blinds. Here's another picture. Same sort of rotation that Nikki Buells is, going around. And here we've got the blinds closed. Here's this mirror pushed up against the window. And now we step outside. And here's where Nikki Buells starts this going around left to right clockwise position. And what we see here, the window is closed. And what we see here in this slide, the window is closed and the blind is closed. So the fact that Riley may have been able to see her for whatever reason, Bobby Jones decided to open the window and the blinds and make it daylight. I don't know. But he is an accident reconstructionist. So here are some assumptions that you have to make that Riley intended to kill Emma, my 18-year-old and 3-month client. You have to assume he knew the height of the bed. You have to assume he knew the height of the box frame. You have to know that he assumed he knew the height of the mattress. You have to assume he knew exactly how she was laying. I didn't put this up there, but you have to assume she hadn't gotten up You have to assume he knew she hadn't gotten up to use the restroom. You have to assume that he knew the number of pillows she was laying on. And I want to go back to what Detective Merritt said in his testimony. Exactly 3 pillows. That's after he's been in the home. That's after he's done his investigation. That's after he's seen this. But you have to assume that my client intended to kill her by him knowing the number of pillows she would be laying on. And you have to assume where her head was. You have to assume he knew that. I submit to you, you have to assume he knew the height of the foundation, height of the floor joists, height of the subfloor, spaces between studs. And you have to assume that he knew this firearm that had never been fired in 13 years was in perfect operating condition. You have to assume that he knew that the gun was accurate. And as you remember the testimony from Jessica Hudson, this is the malfunctioning slide stop. And I want to make something real clear here, that what Ms. Hudson said was, and how she pulled that gun apart in no time flat, was that the way Jim Walker would take that gun apart and put it back together, it would not affect this slide stop spring where she's got this stick pointing to. So this gun was built and came from Glock. Malfunction. Some other assumptions you have to make for Riley, that her room had not changed since the last time he was in there in her living room when Mark Walker caught them, and I think the evidence is clear on that in that October of 2016 that Mark Walker caught them in the living room. I think Haley McDonald testified that there was some intimate relations going on. She knew about that, but nonetheless, you have to assume that Riley knew that that living room or that the bedroom layout had changed. And I understand what happened yesterday. I understand what Detective Merritt was saying. But I also understand that he sat in his courtroom and watched all the other evidence and was available to try to fix some things. And what he said is that they start talking about the height of the bed being parallel with the window. So, Alan Jackson released a song last October 2017. It's called The Older I Get. And one of the lines in it, I can't carry it over the bucket, so I won't sing it, I'll just say it, was, if they found the fountain of youth, I wouldn't drink a drop. And that's the truth. If I've got a hormone left in my body, I don't know. I wouldn't go back to 18 years old. But what I can tell you is that based on common sense, if my client's going in and out of that bedroom with Mark and Jill Walker's permission or not, he is not concerning himself with the height of a bed. That he ever paid attention to the height of a bed as it relates to the window or anything else. And you have to assume that he wanted her gone. We'll talk about the note that they found in Riley's car. Exhibit 292 and 293. And you have to assume that he wanted her gone. This is when they searched the car. Try to read this. I'm very sorry. This is from Emma. I'm very sorry things have to be like this. I love you so much, and I always wonder why God put me and my family as a burden to you. I promise you I'll never leave. I'll never leave, and I still mean that. But I'm just worried that after tonight you won't view me the same. I love you more than words can describe. You're my best friend too, and I can't stop crying because I have no way to talk to you. My life sucks currently, but if I didn't have you by my side, I don't think I'd be alive. I really can't stop crying. I'm so stupid to let them find it. I really wonder what's wrong with me, and I'm so sorry, Riley. I can't stop crying because I saw Grammy crying. Please, oh God, never leave me. I can't live without you. I promise you that. I love you so effing much. I need you here so badly right now because I'm scared and I need you to hold me. I don't know what to do right now because I physically and emotionally can't take this right now. I don't want to stop writing because when I write to you, it makes me feel like you're closer. I don't really know. One thing I never told you is that I have so many letters that I wrote you but never gave. By the time you're reading this, though, you've probably seen some of, and I can't understand the next word, that I keep. You're the love of my life. William, Will I Am, Riley, Gaul. I know it's crazy to comprehend that because we're only in high school, but it's 100% true. That song we heard today that you fell in love with just came on the radio and it made me cry hard. I have so many precious memories with you. That's how I know you're the one. I've known since the first day I ever saw you when you were kissing Bonnie's head. God, I love you so much. With this note, I'm going to attach other ones I wrote and never given, and then the ones I gave that you gave back. I love you so much, God. Never, ever leave me. That's what he had in his car when they searched. Exhibit 305. And that's also what they had, that he had in his car when they searched the picture of him. I submit to you, members of the jury, that that note and those contents are inconsistent with wanting her dead and wanting her gone. Another thing about the Glock is there's been no evidence whatsoever that Riley Gaul ever fired that Glock, ever knew how to shoot that particular gun. And there's no evidence that Riley Gaul knew anything about guns other than what Jim Walker told him and what he had learned about a shotgun. If you believe that part of his interview where he talks about shotgun. It was a solid wall, not a window. This goes back to the side issue. The blinds were closed, the windows were closed. And as I said in the opening statement, some of us who know about firearms may very well know that if you shoot into a house, it'll go through the wall. Some of us may not. And I submit to you, Riley Gaul did not. A 9mm, a 22, a 25, a 40 caliber, a 45. You heard him talking about that in the interview. They asked him about the caliber. You also heard testimony from Jim Walker that he had a handgun carry permit. And he also testified that you have to be 21 before you can get a handgun carry permit. You've heard, I think during the jury selection part of that, if you've got a handgun carry permit, you can rely on your common experiences with that. But there's a procedure, a process you have to go through to be able to get a handgun carry permit. But you can't do that until you're 21. Law enforcement training. Brad Park, if I remember correctly, over 20 years law enforcement experience, and I think he said they have to qualify 3 times a year, and I can't remember if he said they shoot anywhere between 500 to 1,000 rounds a year. To go through the academy, it's a 4-week process to learn how to shoot firearms in class on the range. I asked Brad Park, if you got a bad guy inside the house and you know he's shooting at other people, do you shoot in there? If it can be done safely was his first response. And I said, what if it can't be done safely? Probably not. And the reason is 20 plus years experience, which would make Riley, 38, when these events occurred. 20 years plus experience. He wouldn't do it because it would be reckless. So let's talk about my client's knowledge of guns. So it is true that Riley plays Xbox. And what was fascinating, I thought, and I think it's important to point out, is that of all this wall banging or whatever that came out through Detective Merritt was never asked of Alex, never asked of Isaac, and never asked of Noah, the three people that would play games with him the most. But this is how they say Riley knew how to shoot a gun. A PlayStation 4 gaming console. When you heard the testimony, I don't remember which one of those guys talked about it, about how you worked that particular game. I remember playing Duck Hunt. I don't know if anybody ever played Duck Hunt, but back when it first came out with Nintendo, you had Super Mario Brothers and Duck Hunt. You actually had a little plastic gun. I love playing Frogger. That doesn't mean that I want to go hopping across the street to try to not get run over by cars. I listen to Bob Marley, but I don't smoke weed. The idea that an 18-year-old kid playing PlayStation 4, Call of Duty, with a phrase that was first uttered from the state's attorney, first-person shooter game. The idea that my client had the knowledge at 18 years old of taking a PlayStation 4 controller and that knowledge being transferred to this Glock is absurd. What else does my client have to know to intend the conscious objective or desire to cause Emma's death, the conscious or be reasonably certain to cause the death of the alleged victim? You heard the testimony of, I think it was Brad Park, and he was talking about working with Tommy Finch, and sort of wish Tommy would have been testified in this case. You loved him. He's a fantastic guy. But nonetheless, he was talking about the work that him and Tommy Finch put together. And look at all this information that you have to assume my client knew when he engaged in his reckless conduct. Degrees, 2 feet, 9.25 inches. Now, like I said before, I'm not talking much about premeditation. It's in the instructions, and I'll leave it to that. But I do want to say, before I move on to the next slide, is that for all the reasons that I've mentioned, and I could think of more, Riley Gaul did not have the intent to kill her, did not have the desire to kill her. And I want to say everything the state says about him getting the gun, traveling to Cardinal and firing the first shot is consistent with him trying to get her attention. If you remember the testimony in this case from all the child witnesses, most of them said that Riley tried to get her attention. Two examples that were not part of this trial are, number one, Riley went over to the pool one day and was going to read a book until she came over there. Another one was that he would wait by the door for her at school. And so what was he trying to do on November the 18th? Just trying to get her attention. We'll get to the November 19th instance. I've got a whole other part of it. She reached out to him on November the 19th, and I submit to you that everything that they say about premeditation to kill Emma Walker is consistent with him trying to scare her. Because if you scare her, maybe she'll come have contact with you, and therefore you can try to rehabilitate your relationship. I'm not saying it's logical. Do not think that I submit to you that there's any logic in any of this, because it's not logical. None of it is. But it is consistent with the facts as we know them from the witnesses. It's consistent with the facts as we know them from the 18th. And it's consistent with how Emma reached out to him on the 19th. Asked him to rescue her. As we all know, the first shot was the one that resulted in her death. The second shot did not strike her and is inconsistent with the required for premeditation. How do we know that Riley Gaul was not going to harm anybody but himself, had no desire to harm anybody but himself? Jim Walker was never concerned that Riley would hurt anyone other than himself. That's what he testified to. And also, no other witness other than Isaac Ewers said Riley would be someone that would harm another person. So let's talk. I think the next one is, so even people that knew he had the gun, and they were concerned that he would only hurt himself. And the people that knew he had the gun, Alex, Isaac, and Noah, even Isaac Ewers said that Riley was in a delicate state. That's what his testimony was right there. Said he had issues. Also said he was not doing well in October and November of 2016. He said it was not the Riley that he was accustomed to. Dr. Lockmuller said she was unconscious when the bullet struck her in the side of the head, and there was nothing really anyone could do. I think what he said was you could call 911, but beyond that, I don't think that there was anything else that could be done. Only struck her one time, and he said she may have been unconscious for seconds or hours. Based on the positioning of Emma Walker, he said there had been no movement out of the bed, which would be indicative of consciousness. Didn't see her, and I think there was some reference, he said that there wasn't any screaming maybe. But I think Alex McCarty probably described it best.
Unless it was just like a ridiculous shot. Unless it was just like a ridiculous shot.
A ridiculous shot. Even Alex McCarty, the person who says he was Riley's friend, who calls Riley and I think was participated in trying to get rid of this gun and played along with Riley to do that, working with law enforcement. Even that guy said a ridiculous shot. How do we know that the second shot was fired from the side yard? Now keep in mind, going back to Nikki Buell's testimony, she works in a clockwise position, so 1 is the unspent shell casing in the side yard, 2 is a spent shell casing in the side yard, 3 is a spent shell casing in the backyard, and 4 is a Tootsie Roll wrapper. So what do we know? What we know is John Warren, who lives 150 feet away from, and this is corner to corner of their houses. He's familiar with gunshots. There's 2 shooting ranges in the area, and he told his wife it was gunshots, didn't call the police. Mark Walker, opposite in the same house, thought he heard a door slamming. Emma Walker, closest to the discharge of a firearm, would have woken up if it was discharged at the side of the house first, and there's no evidence of how hard or light she sleeps. This second point, would have woken up if discharge at the side of the house was first. That's consistent with what Dr. Lockmuller testified to. That's consistent with that. So it's clear that the first shot was in the backyard and the second shot was in the side yard. I'm going to change gears just a little bit because I think after my client learned from his mother that something had happened to Emma, things changed. And they changed in a way that they changed in a way that Members of the jury, I think we walk through life, and I think we walk through life in a way that we identify with things. We identify ourselves with things. I'm a lawyer. I'm a judge. I'm a prosecutor. Today I'm a juror. But it goes deeper than that. And I think that, to give you an example, just growing up as a child, being in a small town, dad's a lawyer, and going to these little mom and pop stores, and people say, "Hey, little Stone, you gonna be a lawyer like your dad?" And of course, that's flattering. And so I identified with being the son of a lawyer. I had a good friend of mine who was a chancellor. Grew up when I was a little kid. He was friends with my dad, and he used to call me Pigpen as a little kid. And we couldn't get him to stop doing that when he was on the bench. He was from the bench. He would call me Pigpen, and loved him to death. I considered him a dear friend. But he identified with being a chancellor, and he died as a chancellor. And I think a lot of the community thought that he did a great job, but maybe he should have retired sooner. Up until Riley's 18th birthday, Riley had identified as a Central High School football player, very successful. He identified with his grandfather as being his grandfather's grandson. He identified as being his mother's son. When he went to college, he identified as being a football player at Maryville College. And most important, he identified with being Emma Walker's boyfriend. What a relationship. For a period of 2 years, Jill Walker describes that as on and off for about 10 times. On and off 10 times in a 10-year or 2-year relationship. So what does that mean? And everybody describes it as an on and off relationship. What does that mean? Well, we're on, we're talking, we're communicating, we're getting along. We're off. We don't get back on unless you communicate or talk. So that went on at least 9 more times. The description, and I think it's important to point this out, the description that most of these young people that testified to the state's question would say that they felt like that relationship was they were broken up. Keegan Lyle. If you remember, the only thing I remember, she had a little medallion on her neck. She was one of the witnesses. And what did she say? The state asked her, tell us about the relationship between Riley and Emma. She says, I think it was as it had been, never like done. Never like done. So as Riley has identified with all these people, it's true he's never told his grandfather that he took that gun. Something changed. Walker Stanley, when my client entered the room, what he testified to from the witness stand is they found Emma hurt. Walker Stanley believed Riley's mom was coming to get him and walked Riley to his car. Jim Walker, there were arrangements made for Ashley and Amy to go get him at Maryville College. When Jim arrived, Ashley and Amy were at Maryville College. That's what he testified to. Riley acted like someone who was completely devastated, and no one told him she had passed away. And how do we know that? David Wise. When David Wise goes over to 2311 Woods End Lane or Woods End Road, whatever the extension of that is, said Riley appeared disconnected, blank expression, stoic, in shock, and crying. Believed Emma was still alive, around, and only her. David Wise realizes that Riley doesn't know she's dead. And he doesn't say she's dead. That's not what he says. That's not the word he uses. He uses she's gone. And you heard what he said, my client said. Where did she go? She's gone. Is at that point we submit to you that Riley realized that the stupidity and recklessness and bizarre nature of his conduct had resulted in Emma Walker's death. So what do? You got 120,000 reasons to try to distance yourself from this stupid mistake. And what do I mean by 120,000 reasons? You heard Jim Walker testify. $40,000 a year scholarship at Maryville College. It's a freshman, so extend that out 3 years, $120,000. That's just the tip of the iceberg, and that's not the real thing that's going on here, but why would you distance yourself from that? Well, you don't want to disappoint your granddad. And you don't want to disappoint your mother. And you don't want to disappoint your grandmother. Years old. That's the responsibility that you see. So what's he do? So now there's a transition. Okay, we talked at the beginning about intentionally and knowingly and how it's used in the homicide counts. These definitions have different meanings in the definition sections for these particular counts. So I've sort of jumbled these up. This is not how you would go through it. You go 1, 2, 3, 4, 5, 6, 7. But for purposes of the argument, I think this makes it a little clearer. So in count 2, they charge my client with especially aggravated stalking. See that word again? I didn't put it there. The state put it there. Put it before 12 jurors, grand jurors, based on probable cause, more than 50%. Charging with recklessly causing serious bodily injury as a result of stalking. So the elements of especially aggravated stalking in count 2 are my client engaged in stalking, did so intentionally, and that in the course and in furtherance of that stalking he displayed a deadly weapon, and number 4, that my client recklessly caused serious bodily injury. So what we take issue with in this particular case is the and I may be wrong on this, and I'll just say it, I may be. Number 1, and of least importance, serious bodily injury does not include death. If we look at the definition of that, I think you'll see that. But more importantly, and our argument is, as it relates to count 1. Or element number 1. So if the state proves elements 2, 3, and 4, but they don't prove 1, all by beyond a reasonable doubt, then you have to find him not guilty, which we submit that you will. So this is an exercise that will most likely require you to pull your definitions section out of the jury instructions, because what happens is you get stalking and then it defines another word, and then you got to go look at that word, and then it's got another definition in that word. So I'm going to run through them a little bit, but I want you to understand the but you sort of have to go through that. So stalking means a willful course of conduct involving repeated or continuing harassment of another individual that would cause a reasonable person to feel terrorized, frightened, intimidated, threatened, harassed, or molested, and that actually causes the victim to feel terrorized, frightened, intimidated, threatened, harassed, or molested. There's an inference in that instruction that talks about if the no contact is requested by the victim, it has to be non-requested by the victim. And the course of conduct, as Mr. Allen was correct, means a pattern of conduct composed of a series of two or more separate non-continuous acts evidencing a continuity of purpose. So then you get into the definition of harassment. And out there it is on the screen. And then there's a reference as to emotional distress. So here's another place you have to look for a definition of emotional distress. Part of this definition is you have to have unconsented contact. And that means that it's initiated or continued without the person's consent or in disregard of that person's expressed desire that the contact be avoided or discontinued. Your pattern instructions, the instructions that you'll have, will have the non-exclusive list of other types of unconsented contact. I didn't want to put them up here. They're there for your review, and you can apply those to the facts of this. So what do we know about stalking? 18th, 19th, and 21st. That's the dates that they say give rise to the stalking. So we got to go through each one of them. We know that on November the 18th, things occurred at the Sarah Seaton residence. We know that there were text messages from a number from this verse. Maybe we don't know that there's a phone call, but we're fixing to find out because it's in the exhibit. What we know is that Haley McDonald said, that's Riley outside, Emma went outside. I think Zach Green, I'm not exactly sure which one said that Riley that Emma made a beeline to Riley, but one of those people in that event did talk about that. And it's our position that that's consensual contact. We've got some more to talk about. The next one is Saturday morning, November the 19th, 2016, 6802 Cardindale. This is where Jill Carney has a video camera pointed at Colston Drive. And what we know from, and you've got the exhibit, is that Emma reaches out to Riley and says, I hate you, but I need you. And we submit to you that Riley was not the person that morning. We'll get to that in just a second. But Riley was not the person that morning who was trying to get into her house. So here is the records from the apps verse, the spoof number, and what we know is that this UTC stuff that we have to subtract 5 hours, and I made that note up there just so I won't forget that number if I got up here and forgot it. But anyway, you have to subtract 5 hours. That's what was testified to, and I think the party stipulated that. So what we have is this number going to Emma Walker saying, go to your car with your keys, go along, and she says, who is this? Says, what part of the loan wasn't clear? And she responds, yeah, I'm not, because I don't know who this is, LOL. Says, I don't want to hurt a loved one. Something about, you tell anyone about this, I'll hurt her feelings. She says, Emma says, show me, LOL. Here she says to the person, I know you're one of Riley's friends, but stop. I know you're Riley's friend. I'm not stupid and you won't hurt him. I know Riley put you up to this, LOL. I'm not dumb. I'm blocking you. This is BS. So all those text messages stop back and forth. And what we find is phone calls pick up. And right here, the anonymous person's texting is in the ditch, all this stuff, okay? Oh, those are text messages, I'm sorry. And so right here is where we have the phone calls. They pick up at what, 12? Let's see, I struggle with that, 11:55. But what's telling about these phone calls from the anonymous number to Emma Walker's number, all the way down until you get right here. On November the 19th, 2016, at 7:46 a.m., Emma Walker calls this number. And Emma and Riley talked for 7 minutes. If you add all those times that they talked, 15 minutes total. Now, I want to point out something that I think is very important. And I don't remember which of the young ladies said it, but what they said was, when Emma is arguing with Riley, she gets in a mood. And if you remember what was described on November the 18th, Emma was texting and was in a mood. She was in a mood that looked like she was arguing with Riley. That's number one. So what do we know? We know Emma went out 3 times. We know that at least 2 of the witnesses testified, and I think all of them agreed, that everyone believed it was Riley who was doing the spoofing thing with the text messages. Haley McDonald tells Emma before she went out the second time, "That's Riley." And Emma goes outside. No one told her not to go out. If she wanted to confront Riley about it, the confrontation we submit to you was consensual. If she only wanted to talk to him, we submit to you it was consensual. No one told Emma to go outside. When asked to leave, Riley left. There was no threat of harm. Zach Green suggested that Barry Seaton call law enforcement. Barry dismissed it as consistent with Riley's past conduct, and we submit to you that based on Riley having been older before, and Barry knowing Riley, that he too was not concerned that Riley would hurt anybody. November the 18th, 2016, again we've got the dismissal by Barry Seaton. No one called law enforcement. No one called Jill or Mark Walker. And Riley left when he was asked to leave. Now we move into November the 19th, 2016, and what we have here, you may recall Crystal Gibson's testimony. She talked about a 35-minute delay, which just conveniently I submit to you as based on one of the exhibits introduced yesterday of a 36-minute travel time to Maryland from 6802 Cardindale. It's 36 minutes, and it's coincidental, I guess, that that's a 35-minute delay, but nonetheless a coincidence worth pointing out. What Crystal Gibson says is initially that there was somebody wearing black at 10:01 walking toward Cardindale. Later she says it was dark, and what she said we were looking for after Mr. Allen asked her regarding black was that she was looking for a black sedan. So this is the person we submit to you. The state is saying is Riley on the video. Jill Carney, camera viewpoint, 10:04, shows a person running across the road, heading in a northeast direction, which would be away from the direction of the pool, where the state says my client was parked at that time. So we submit to you that running in a northeast direction, being inconsistent with that particular, going back to the car, as the state says, illustrates that it was not Mr. Gaul who was trying to scare Emma or break into her house or whatever they was trying to do. The person on Jill Carney's video was not Riley, and I think it's very, very interesting that Haley McDonald, the bookends of the child witnesses, Sarah Seaton was first, Haley McDonald was last, that it was not shown to her to say, you know what, that's Riley on that video, I know his gait, I know how he carries himself. They could have showed it to her if it already came in, but they didn't do that because they're not sure. How else do we know they're not sure? Emma didn't say it was Riley, and Emma in fact said it was not him. And at 10:33:36 at Exhibit 20, which you can see, Emma texted the group, he FaceTimed me speeding over here. We know by now that FaceTime is an app that permits you to video your call, and that's what she told the group, that he FaceTimed her while they were going over there. And that phone call, I'm not sure where it's at. It's in one of the exhibits. We had it, and I think it's 2 minutes or something long, that FaceTime phone call. For it to be Riley, he would be running toward the pool. Jill Walker did not describe Riley as being out of breath or sweating or other characteristics of Riley running all over Sturkey Hills. The state says that Riley would have been doing using his athletic ability. And I want to talk about the car a minute. Haley McDonald talked about the car in this courtroom from that witness stand. Over a year later, Haley McDonald says that she immediately knew it was Riley's car. That she immediately knew it was Riley. I said, well, now let's talk about, you said earlier, 50-50, and I confronted her with what she said back on November 21st. Here's the jury, I don't fault anybody. I ain't casting blame on anybody. These are young people who, in the world of public opinion and social media, I submit to you, Haley McDonald's picked a side. That's naturally what she would do. But when I asked about if she was 50% sure and 50% unsure, does that make you sure? She agreed that she would not be sure that it was Riley's car in the parking lot at the pool area. On November 21st, 2016, she said she thought it was his car. Last week she said she immediately knew it was his car. And when confronted about the 50-50, she became hostile and agreed that she was unsure. On November 21st, she said she thought it was Riley in the neighborhood. She did not call law enforcement. Instead, Haley McDonald reached out to Riley. Hey, what are you doing in Sturkey Hills? He said he wasn't there. If she were sure that it were Riley in the neighborhood, she would not have to go to the parking lot to check. She says the person walked toward the pool. I thought the video showed him running across Coastal, going northeast. In trial, she immediately knew it was Riley walking. Here again, why would you have to go check the pool to see if it was Riley or not? So we submit to you that Riley was not the person trying to get into the house. And I don't know who this salted potato guy is, but in that chat thread where the state the state talks about Emma being scared, he says it was me. I just wanted to love you, and Sarah Seaton described him as sarcastic. I don't know what all that means, but that's what's been introduced. So what do we know from the exhibits? At 10:04:24, and all these except this particular reference comes from Exhibit 352. This is Exhibit 13. Jill calls Emma at 10:04:24, and that call is for a period of 1 minute and 24 seconds. Emma did not tell Jill what happened the night before. Or what was going on at the house. At 10:16:02, Emma sends a text to Riley, "Who's at my effing house?" And that's Exhibit 352. At 10:17, Emma sends a text, "Someone's at my effing house and I'm home alone." Both text messages sent to Riley Gaul. That's in this exhibit right here, 352. At 10:17:40, Riley says, "I'm on my way." 10:17:45, Emma says they're walking around. 10/20/18, Emma says they walked away from the front door and I'm leaning on the back because the lock's broken. 10/20/38, Riley says I'm coming, hold on. 10/20/49, Emma says where are you? Riley says passing Applebee's at 10/21. Now, we stop here a minute. We do not say this is the same time that the phone call to the AT&T records was made from Riley to Emma. This is not the time when we say that happened, okay? The point of showing you the images of Applebee's in relation to the cell phone tower at 10:35, I think 35, and you'll see here in a second the time, was to show the orientation from the cell phone tower, Applebee's, and Cardindale Drive. And I put that on through Detective Mary. 10/21/07, Emma says that's too far. 10/22/22, Riley says where are they now? 10/23/04, Riley FaceTimes Emma, and the duration of that call was 2 minutes and 25 seconds. And then at 10:35:52, Riley calls using the cell phone tower. That's Exhibit 45, and that's near Applebee's. Not trying to confuse you. I just want to show the orientation of Applebee's, Cardindale, to the tower. This timeline establishes that his contact with her on the morning of November the 19th was with her consent, and when asked by Jill Walker to leave, he left. Okay, so count 3 charges my client with theft of property over $500 to less than $1,000. There's the actual copy of the county presentment. You'll have that. Here are the 3 elements. My client exercised control of the property owned by Jim Walker, did not have his consent, intended to deprive him of the property. Members of the jury, all that's true. This is just what it is. But when we were asked to be called to plead to the various charges, I said we plead not guilty to count 3 because what we knew was that at the time of the offense, on November the 18th, 2016, when Mr. Walker talks about taking Riley's car and doing the things with it, is that's when the gun went missing. Here's the definitions of knowingly. They're in the definition section. And intentionally, they're in the definition section. But what we know is he's charged with over $500 less than $1,000. Mr. Jim Walker purchased it in 2003. There's no direct or circumstantial evidence that it was ever fired prior to November 21st, 2016, except by Glock, and that the firearm was malfunctioning. Clearly, he paid $509 for it in 2003, I believe it was. But the proper way to establish value, and Mr. Walker did it, assuming you had a willing buyer and a willing seller, and neither party under compulsion to buy or sell, what would that gun have been worth right before you lost sight? What did he say? $350, $400. So the purpose of the plea of not guilty was, I couldn't plead, we just couldn't, the way you structured, I couldn't say not guilty to the count charge, but we plead guilty to the lesser offense of theft under $500. But clearly, that's been established. As of, I put November 18, 2018, I'm sorry, it should be November 18, 2016. He's not guilty of what he's charged with in the presentment, but he is guilty of the lesser included offense of theft under $500. Okay, so with tampering with evidence, on this one, when the court read to the jury, my client was called one in the plea, I said not guilty. In opening, I said listen to the evidence. And here are the elements of those two, of that particular offense. I knew all this stuff was going to come in about not necessarily concealing it to prevent its availability in an investigation, but I knew all the other stuff was going to come in regarding Alex and Noah and getting rid of the gun. And so, members of the jury, I have to submit to you that based on the evidence, that Mr. Gaul would be guilty beyond a reasonable doubt of that offense. I can't argue with that. I can't argue with that. So, here, employing a firearm for the commission of a dangerous felony, Mr. Allen has stated that my client has pled guilty to employing a firearm, but I want to be clear that he's pled guilty to reckless endangerment. It is true that that did include the discharge of a firearm, But this is a two-part test. My client employed a firearm, the employment was during the commission of a special aggravated stalking, and that my client acted intentionally, knowingly, and recklessly. As those three words are defined in the definitions portion of your instructions. Two-part inquiry, he's already accepted responsibility for discharging the firearm, therefore the employee would be satisfied. However, for the reasons that we've said, all the reasons that we've said regarding special aggravated stalking, I'm sure you don't want to hear me argue those again. We submit to you that the second part of that is he did not commit the predicate offense of the special aggravated stalking beyond a reasonable doubt, and they've not proven it beyond a reasonable doubt. So here's what is very, very difficult for me. I don't concede things well. I think anybody that knows me would agree with that. But keeping with the truth and keeping with the evidence, we actually find Mr. Gaul guilty of reckless endangerment in count 5, which requires that he engage in conduct to place another person in a walk or an imminent danger of serious bodily injury by acting recklessly with a deadly weapon, and that he discharged it into an occupied habitation. We ask that you find him on the homicide counts 1 and 7 of the lesser included offense of reckless homicide, which requires him to have killed Emma Walker and that he acted recklessly in doing so, theft of property under $500 in count 3, and tampering with evidence in count 4, which requires him to have concealed the gun with the intent to impair its availability in an investigation. What we know from Exhibit 353 is that as of November 21st, 2016, Emma Walker did not have Riley Gaul blocked from her phone. What we know from Exhibit 354 in the calls from Riley to Emma in the month of November, which there were 538, but the last phone call that they had by FaceTime not exactly sure, November 19th or 20th, November 19th. Yeah. What we know from Exhibit 355 is that on November 19, 2016, at 10:23:04, which we talked about, that there was a FaceTime conversation at 2:25, or for 2 minutes and 25 seconds. And what we know circumstantially, I submit to you from Exhibit 356, that Riley was helping Emma with the homework, where he expresses that he will help her if she'll just talk. And that's on November 20th. And I suspect that Mr. Allen will have a lot of things to say about that particular report here in just a minute. I thought about that coming in this morning. I submit to you members of the jury, it's a lot like sitting next to somebody having a phone conversation that you're not participating in. After you listen to some of the things that they say, you can infer from that what exactly that conversation was about, and I submit to you that Mr. Gaul was helping her with her homework on that particular day. But what's really interesting about this on and off relationship with Mr. Gaul and Ms. Walker is that Exhibit 43, Max Siegel's phone that Riley would use to communicate with him. There are 61 calls, most of which are FaceTime. And number 10, if I recall correctly, is the 14-minute and 26-second telephone conversation that Emma and Riley had from Mac's phone. A little bit later, they talked for 47 seconds. A little bit later, they talked for 31 seconds. A little bit later, they talked for 33 seconds, 14 seconds, 15 seconds, 11, and 3. And then at 11, on 11/21/2016, 12:09:02 a.m., Emma calls Mac's number. Riley calls 2 more times from Mac's number, and that goes through 61. So, the way this works is, when I sit down, I don't get to say anything else. That's hard for me, not say anything else, but what I ask you to do is, when Mr. Allen says something, or Ms. Martin says something, ask yourself, what would Wesley say based on the evidence? What would Wesley say based on the evidence? So what do we know? What we know is, when crime scene technicians came into Emma Walker's bedroom, she still had this photograph on her nightstand. We also know that she had 2 or 3 cell phones in that particular room. And this note, Exhibit 11. If I could go back in time to before we met, I'd look for you and find you sooner. So I can love you longer. I love you so much. I hope you're going to stay with me forever. I need you, Em. I love you. Signed, Riley. I love you so much. I love you so much that I can't let this strong relationship I have with you go. These are just words, but my actions will far surpass these words. I can't stress it enough how bad I want you. You're all I want in a woman and all I ever want. Forget about everyone else. I only want you with me. I reread your letter every day. To remind myself you love me. When you read this, I hope you realize how bad I want this and how much I'm willing to do. Forget football. I worked so hard for it, but it's only around for so long. If I had a scholarship offer from Oregon or Alabama to start and go to the NFL or rekindle my relationship with you, I'd no doubt choose you. You're my everything, Emma. I will never give up. I will do everything in my power to make this right. I will have you back, Emma Jane Walker. Mark my words, when you do take me back, you will never have to worry again. My actions will prove so. I love you with all of my heart, soul, and being. This photograph that's on the wall was at a time where I submit to you, my client was her hero. So to be somebody's hero, to rescue somebody, you have to have contact. And the only way you can get contact is to get their attention. When Riley Gaul fired that shot in the backyard, as crazy as it is, and as bizarre as it is, he was hoping that he could come to her rescue. He didn't hear any screams. He didn't hear any lights come, didn't see any lights come on. Certainly didn't believe that he had struck her, because if he had, he wouldn't have fired the second shot. Because maybe she didn't hear the first one. Members of the jury, I ask you to find my client guilty, as I have asked.